not moving. I think it's moving, just the second is not
It
moving.
moves, just it's red, so it's hard to see.
Oh, really?
the
Oh,
red
you're
and
right. Okay.
It's hard to see the red on the white and the green, especially with the light right above it.
Rob, have you gotten too used to digital clocks?
That's the problem.
Yeah.
It
did you
is.
skip
I can
fourth
barely
grade?
tell time anymore using the. Anyway, thank you for all coming. Welcome to the Village of Rybrook Planning Board meeting, and let us all rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Again, welcome, and thank you for coming. My name is Rob Goodman. I'm Chair of the Planning Board. My colleagues in attendance are Kevin Branch, John Gerzan, Scott Mendelson, and Lenny Vaisman. Amy Shum and Ed Teig are excused for tonight. Also in attendance is our liaison from the Board of Trustees, David Heiser. See, I've not forgotten you. And now you're front and center, David. Our village attorney, Judson Siebert, and his colleague Pam Vigna, our superintendent of public works, Michael Nowak, and our planning consultant from Hardesty and Hanover, Sarah Brown. Our board secretary, who is not here but is involved always behind the scenes in making these meetings happen, is Tara Orlando. And I don't believe we have any minutes for this meeting. And our first item on the agenda, I think, has been adjourned. That's 15 Lock Lane to next month. Do we need to do anything formal with that, or is it just, it's off the agenda? Okay. All right. So our first item is 900 King Street, relating to amendments to the site plan.
No crossway.
And I believe a public hearing has already been. We closed the public hearing. Okay, that's fine. All right.
Good evening, Mr. Chairman, members of the board. David Steinmetz from the law firm of Zarin and Steinmetz here representing Sunrise Senior Living, together with Anthony Nestor, our project engineers at JMC Engineering and Planning. We have no presentation for you this evening. We're here to answer any questions. As I think you all know, we appeared in front of the Board of Trustees. We were pleased that the Board of Trustees reaffirmed and readopted their finding statement concluding the New York State Environmental Quality Review Act, SECRA, finding statement process, allowing this board to now proceed with the amended PUD approval.
Right, and I believe there's either a finding statement that's been presented to us. Does any member of the board have any comments or questions concerning the finding statement, council? No? Do we have to formally adopt it here, or?
Yes.
Okay.
Yeah, so the board's been presented with both the standalone finding statement, which is the document that will be issued for secret compliance, and then the resolution basically adopting it as your own as an interested agency.
Got it, got it.
The finding statement that was presented to this board, it's a smaller version, if you wish, of the one adopted by the Board of Trustees, or?
Correct.
Yeah, okay.
And it's applicable to us to the extent that there are amendments. So that's, sort of our jurisdiction. So unless there are any comments, let's adopt the finding statement.
Would you like a summary?
Okay, if in brief, though.
The planning board has before it two documents for consideration pertaining to the involved agency second amended finding statement under the State Environmental Quality Review Act. The first document is the finding statement itself, and the involved agency, of course, is the planning board, and the proposed action is 900 King Street redevelopment, which is an unlisted action under SECRA. This finding statement was prepared by the village council and vetted by town staff and consultants. Village staff Please strike that from the record. In preparing this involved agency secret statement, the planning board relies on the facts and analysis presented in the draft environmental impact statement and the final environmental impact statement and the current environmental record before both the village board and the planning board. The description of the action is included, and it is known as the second amended PUD site plan for construction of an integrated age-restricted residential community replacing an existing largely vacant office building and surface parking lot at 900 King Street. The history of the action is that in 2021, the applicant submitted a PUD site plan. It revised that plan in 2025 by what the finding statement refers to as the amended PUD site plan, and then in 2026, the plan was further refined and became known as the second amended PUD site plan, with the following proposed changes, which are found on page 3 of the finding statement, involving relocation of townhouse footprints, reconfiguration of the loop road, the sidewalk and walking path, modifications to the sanitary sewer system, modifications to stormwater system in the garage, modifications to the generator space and the trash area, reconfiguration of allocated parking and land bank parking, as well as architectural modifications. The finding statement describes the project site and the proposed project, which does not propose a change in the number of proposed units or the number of proposed bedrooms. The planning board in the finding statement makes reference to the lead agency, which is the Board of Trustees, prior 2021, 2025, and 2026 statements of findings pursuant to SECRA. The lead agency's prior analysis is retained and is supplemented by a description and analysis of the impacts presented by the second amended PUD site plan. The planning board, as an involved agency, has reviewed the changes proposed, and as a result of the second amended PUD site plan, it concurs with the findings issued by the lead agency and finds that its second amended further reduced alternative minimizes the environmental impacts to the maximum extent practicable, consistent with social, economic, and other essential considerations. There's an environmental analysis on pages 6 through 9 that includes analysis of land use, public policy, and zoning, geology, soils and topography, water and wetlands, stormwater management, vegetation and wildlife, visual resources and community character, community facilities, infrastructure and utilities, traffic and transportation, and construction. Pursuant to Article 8 of the ECL, the Environmental Conservation Law, and its implementing regulations, and after due consideration of the relevant impacts, the Planning Board, through this finding statement, certifies that it has considered the relevant impacts, facts, and conclusions disclosed in the DEIS and FEIS. It has weighed and balanced the relevant environmental impacts with social, economic, and other considerations. The requirements of 6 NYCRR Part 617 have been met. Consistent with social, economic, and other essential considerations from among reasonable alternatives available, the second amended further reduced alternative, as modified by the statement of findings, avoids or minimizes adverse environmental impacts to the maximum extent practicable, and adverse environmental impacts will be avoided or minimized to the maximum extent practicable by incorporating as conditions of any site plan approval within the project site those relevant mitigation measures identified in the DEIS, FEIS, and this statement of findings. In the statement of findings, the Planning Board certifies that its obligations as an involved agency under 6 NYCRR Part 617 have been met. And then the second document the Planning Board has before it is the resolution, which will adopt a SECRA second amended finding statement as an involved agency for the proposed actions submitted by Sunrise Development, Inc. for property at 900 King Street, the resolution will effectuate and adopt the finding statement previously described.
Okay, so we only have to take one vote to both adopt the finding statement and the resolution. I guess the same thing, right? Okay.
Mr. Chairman,
Yes, please.
I missed the last meeting, so I apologize if what I'm going to ask was discussed last time, but I read the finding statement, and there were two memos that I read in preparation for this meeting. One was from the Arbor's attorneys, and one was from the Westchester County Planning Board. When I believe, and I just wanted to make sure that the attorneys do agree with my interpretation, that what was raised in those memos has been in effect addressed in the planning statement.
Yes, I mean, not, and not.
Not
well,
directly, but in
well,
the- yes.
But certainly with regard to all of the prior secret review
Yes.
that preceded the initial adoption, of the approval by the Board of Trustees.
Yes.
The amended site plan adopted by this board, and as incorporated most critically in the approving resolutions that have followed this, this project.
I mean, just to clarify for my self-edification, these memos that John has brought, is discussed, they do not affect the amendments that are currently before
the-
us. They related to the original site plan.
Correct, and I think like an overarching comment I'd like to make with regard to this amended approval, and we'll get, presumably we get past the adoption of the finding statement, and we get to a resolution approving the amended approval. The observation I would make is that we are talking about a collection of modifications to an approved plan that, quite frankly, if taken singly or maybe even in smaller groups, could possibly have been dealt with as field changes and not even required or triggered review by this board or the Board of Trustees. But village staff looked at the totality of those changes and felt it prudent, just as a, belt and suspenders approach, to have them incorporated into a second minute approval. None of those changes, either as a whole or on an individual basis, implicate or involve any of the issues that are raised in the memos and the correspondence you're referring to. Those comments were all previously addressed in prior secret review and prior resolutions.
Thank you, Judson. Thank you.
Unless there are other comments or concerns, can I have an emotion and a second to adopt the resolution adopting the finding statement?
I move to adopt the
Second.
finding statement.
Mr. Branch?
Yes.
Yes. Mr. Grzan?
Yes.
Yes. Mr. Mendelson?
Yes.
Yes. Mr. Weissman?
Yes.
Yes. Chairman Goodman?
Yes.
Yes. Thank you.
And the next resolution relates to the approval of the amended site plan by the planning board, as I understand it.
That's correct. And that resolution's been provided to the board, dated as of today, May 14th, 2026. It opens with a collection of whereas recitals that really go through the whole history of the application, the prior approvals, initially issued by the Board of Trustees, the amended approval issued by this board. It then identifies, as I just mentioned, those collection of modifications that are now folded into this application for an amended approval. As Ms. Vigna indicated, there are no modifications in terms of number of units or bedrooms. It also recites what the action this board just took in terms of adoption of its own finding statement, and also the Board of Trustees' adoption of an amended finding statement as secret lead agency. References the plans that have been provided and reviewed, and then approves the second amended site plan, and imposes what I would say are basically a reiteration of a lot of the conditions that were attached to the prior approvals.
Okay.
I
Unless
have,
there are, go
I
ahead.
have one comment about that, and I understand what council just said. There was new information that came to light in the last meeting, at least to me, that there is and I don't know I'll rely on council for the legal argument or standard that we should follow. But regarding an easement that exists for the benefit of the school, that runs over Arbor Drive and into the project site. And, I just I can't not notice, or I do notice, that it's not reflected in the resolution and the site plan amendments. And so I understand that I'm being told that an existing path that is noted on the site plan is that easement that benefits the school. But in the resolutions that go along with the site plan, there's mentions of easements in favor of the applicant and in favor of the arbors or the arbor's maintenance of the road, absent is any mention of the school's easement. And so I just, that came to light via a letter that was submitted to the board before the last meeting. And I just, I'm just raising that as something that I see that's not present in this site plan amendment.
So I'll respond. First of all, there is an easement that is held by the school district that traverses a portion of the project site. It has been part and parcel of the site plan and PUD application from the outset. It's shown on the plans. There is no, intended, alteration or disruption of the easement. And for that reason, it's shown on the plans. There's no indication by virtue of what's proposed that there will be any interference or obstruction of that easement. In fact, the plans call for a crosswalk that will really facilitate that easement. I think the reason there's a distinction between recitation in the resolution, the original resolutions, and amended resolutions that differentiate between the easement over Arbor Drive as opposed to the school district easement is there is some work proposed in terms of sidewalk work in Arbor Drive, whereas there is none relative to the school district. So it's there. There's no change. There's no interference, and it's really not for this board to validate or further enforce rights of private parties by way of easement agreements.
Yeah, I think Scott's concern was that this is an issue that was sort of never raised, and even by the school, and so he was concerned by that, and we needed an explanation as to why that easement. There was no discussion about that easement or any efforts to create conditions to protect that easement. But
I'm not even sure what the easement is by reading of the deed. I don't know what the easement is and what it's for. It seems like a path to nowhere on the map, but I don't know without examination as to what the intent was there and what is and shouldn't be or should be considered, in this project with that. I don't know if it was missed. Certainly when I'm looking at this, I would have liked it to be noted as an easement on the plan, and I would have liked it referred to. No, I think it's noted as a existing. Is that the existing sidewalk easement?
Yes.
There's two things on the plan. One is a delineation of the actual easement, right? And then there's an existing path that's shown, and if you look, the existing path that's actually used does depart and is a bit outside of the confines of the recorded easement, but there's no plans to disrupt that. And if there is a school district issue relative to that alteration, which has been in use, it's really for the school district to raise.
That's
Well,
Mr. Chairman, if I may assuage Mr. Mendelson's concerns, and at least try to.
Yeah,
Because
sure, I
this was
agree.
raised last time, and I've had an opportunity in the intervening month or so. There is an existing easement. I don't have it with me. I don't know the exact date of the original easement. And whether you all dealt with this in your original approvals that we were not involved in or not, we are re-recording an easement with the school district because, as Judson just indicated, we want to make sure that the path is located within the easement. So the easement is going to be, we expect, assuming the school district and my client agree, which it's a very simple 3-page document, we're going to re-record the easement. We're going to make sure that the meets and bounds description of the easement area is coterminous with the actual pathway that's there. Anthony Nestor explained to me that the pathway that's there is actually going to be repaired in part. So Judson said something I want to correct for the record. We actually are touching a portion of that pathway and making it better. We want to make sure that because it crosses what will be my client's property, it's in good physical condition. There will be an easement more clearly granted to the public to utilize this with specific reference to the benefit for students to get to and from, as I understand it, correct me if I'm using the phrasing correctly, Harkness Park. That's the phrase that's used in the original easement document. So we have a very clear illustration. It's part of our plans. We're gonna fix that one section of the walkway. We're gonna re-record an easement to make sure that that walkway is within the easement area, and it's gonna be entered into between my client once it owns the property and the Blind Brook School District for the benefit of the public, pedestrians, and with specific reference to school children. One last thing, we're also making it clear, because it's not clear in the easement, that it's for pedestrian utilization only. It's not for motorized vehicles and anything that would create a dangerous condition on my client's property or on the piece that connects to Harkness Park. The last piece, and I think this to me is the overriding concern, having just driven it again to see exactly what we're talking about. The one thing that's not there from a safety standpoint is a clearly delineated crosswalk. The resolution does deal with that. My client has an obligation to stripe out that crosswalk and to sign it appropriately. And for those of you who know Arbor Drive currently has very small signs regarding the speed humps. It will now have signs regarding the crosswalk. So the crosswalk will be striped, clearly delineated, and signed so that vehicles coming and going know that there's a crosswalk that school children may be on. So again, I don't want to speak, Mr. Mendelson, to why it was or wasn't addressed in earlier resolutions. We are addressing it because we know we need to, because it's on our client's, what will be our client's property.
All that sounds great, and thank you for doing that.
Yeah.
I truly appreciate that, and I'm sure the residents do too. You know, with that said, would you be amenable to an addition to the resolution that the school district's easement is not to be disturbed by this construction?
I leave that to I don't want to speak to the construction implications. I don't know whether we're. So I don't, that sounds like a representation I don't know if we could actually safely make. So I don't want to make any.
There is going to be an agreement between the school
Clearly.
and.
Well,
and-
I mean, but
and the-
we're here, there is going to be construction to this easement.
Yeah,
So
but
I do think it now falls under a different standard.
So on that, here's what I'm going to try to respond on the fly, Mr. Mendelson and members of the board. There is an easement that's an existing easement between private property owners. The 900 King Street, as it's currently owned, and the school district. To the extent that my client purchases that property and does any activity on that property, it can't interfere with the ability for people to make use of the easement even if it wasn't in the exact place. So if we're doing some construction and there's a piece of equipment in that area on a given day, there'll obviously have to be arrangements made for the public and for school children to traverse around it in a safe fashion. Your question was, can I tell you that that exact easement won't be impacted? Anthony, can you address that?
Yes. Good evening, Anthony Nestor with the firm of JMC. There will be construction in and around the existing path once you get up for location-wise to where the existing parking lot is now on the site. But there is going to be, there's work that needs to be done to the existing storm water basin. There's some grading and parking that's gonna come relatively close. But I thought, and excuse me, I'm trying to find it though, in one of the conditions of the resolution that says in there with regards to temporarily relocating that easement during construction, I think it's stated it as one of the conditions.
There is a condition, and this was, you hit on, the condition as I read it is in favor of you for your easement and with regard to you and the arbors, what it's missing is the school. And so I'm not clear on what the school's easement is. I don't know if anybody is specifically clear on what the school's easement is, and that's not my job, and that's not, I understand that. What
I mean, this sounds like it is something, this is an issue between two private parties. And presumably, the school knows what its own easement is for, and that, or it may not, but it's entering into a discussion with you about protecting that part of the property. And the remedy that the school would have would be against the developer or against the owner of that property if there's an obstruction to that way, the parkway or pedestrian walkway. And so I think there are protections in that private agreement that will eventuate, that will protect the integrity of that part of the property.
So I agree with everything you said, Mr. Chairman. It is between private property owners. It's not expressly part of the resolution. Mr. Mendelson's concern as a member of the planning board and a member of the public is a fair concern, and I kind of think we share it. Nobody wants to own a piece of property where prior folks have created easement rights in favor of the public and children to traverse it and have a construction site create an unsafe condition and just kind of ignore it. So if you're looking for a representation, members of the board, whether it's part of the resolution or not, I can assure you that if we have to fence off the area with appropriate snow fencing during construction, that will be done. If we need to take any other precautions, if in fact there's construction in that area, that will be done. I think when I call the school district attorney with the new easement to say, can you review this and are we good entering into this new easement, likely this issue comes up between my client and between the school district, and it will be rectified. So nobody's ignoring this. We're going to spend money on the pathway. We're going to spend money on the crosswalk, and again, I don't know why it's not in your earlier resolutions, and we're not changing anything. Let's take one giant step back. In fairness, and I'm responding to your question. You asked it last time. I looked at it, and I'm responding tonight. I'm not here tonight on anything having to do with changing anything regarding the prior approvals that your board granted concerning this property and this easement. I'm here in connection with, as council indicated, minor modifications to some of the locations of things and some of the other improvements. So jurisdictionally, I'm really not here to talk about the school district easement, but I'm happy to do so. So I want to answer your questions. I want to try to assuage your concerns. We're not ignoring this.
But I think that's, Scott, that's, if I may, it's almost a construction matter.
It is.
And it could be addressed to everybody's satisfaction in a construction management plan.
Well, my concern isn't, and I understand, you know, and again, I'll be advised by and guided by counsel. I very much appreciate your attention to this, and my concern isn't just with construction, although it is with construction. It's also, I don't know what the easement is for, and I don't know what the intent was, where it was supposed to go. I don't know, because it's very unclear in the deed. And there are easements reflected in the resolutions and discussed in the resolutions. Every easement except for this one. And as a member of the community, and it's the school's easement, that
Yeah,
bothers me.
but there may not be an answer to that question, and that's why it may have to be revisited by the parties that are immediately involved, and they are going to have to come to some sort of resolution as to what that means if, in fact, the law relating to that and the rights and duties are not altogether clear.
I'd also like, just in the resolution that the board has before, a couple of points. First, there is a condition that requires coordination with the school district prior to commencement and demolition to minimize the potential impacts to students and teachers. So that will
My
occur.
concern isn't just the construction. I do have concerns over the construction. My concern is that there's not going to be that we're not approving something that would, I understand what council is saying regarding the easements and the rights of the parties, and I'm not sure I agree that it's a private party, that the other, you know, the school is a private party. I'm not sure I agree with that. But
But they are party to the proceedings. and they could have raised the issue.
Right, but we deal with neighbor issues all the time.
Yeah.
Right? And without them appearing. We deal with pool equipment that we don't want next to a neighbor. We deal with items like that all the time, even without anybody interjecting. And I think we would be remiss not to at least try to add something to the resolution. Maybe it's there,
But
It's
we're not
paragraph
changing
41.
we're not changing the easement, we're not touching it.
but we don't, we
This is- our-
overtly,
our
overtly
amendments-
mention the other easements, not this one.
I mean, I think that the amendments that we are dealing with are not affecting
Not at all.
this
Yeah.
easement.
But let's address this, because he's put it on the record, and we're making a record on this topic, so because we didn't shut the discussion down completely, which would have been unfair.
Which we appreciate.
And would have been, in my opinion, jurisdictionally lawful, but would have been improper. Let me just respond.
Yeah.
Because I didn't know this was coming at me tonight, and I appreciate the opportunity to now respond definitively on the safety issue. You all have addressed the safety issue. During construction, the site shall be fenced off to the satisfaction of the building inspector to ensure safety and the pedestrian path leading from the village buildings to Harkness Park and the Blindbrook High School shall be temporarily closed. The applicant shall be responsible for securing the pedestrian path on site so it cannot be accessed, and shall post signage directing pedestrians to the existing sidewalk on King Street where pedestrians would cross Arbor Drive at the existing signalized crosswalk. So, I was pretty close on the fly answering your question about what I expected might happen. I'm now going to be definitive on the fly and tell you that you all have mandated precisely what has to happen with regard to during construction. I know you have concerns, Mr. Mendelson, about the existing easement. I mean no disrespect to the folks who drafted the old easements. I'm going to tell you, and I'm happy to, if you haven't looked at it,
I've
and you're
seen
obvious, there's not much in there.
It's why I don't know,
I can
what
assure
it's,
you,
what it
the
was
easement
for.
that I have drafted, I hope is a little clearer. You've heard me, and I don't have it with me tonight because I didn't know you were going to ask about the future easement between my client as property owner and the school district, but it's going to give pedestrians, not just school children, because I don't want to have to make my client a policeman for whether people walking happen to be school children, teachers, aides, or some member of the public. It's going to be a pedestrian path and a pedestrian easement crossing my client's private property to get to Harkness Park. No motorized vehicles.
I mean,
And I think I have a provision in there that if somebody creates a disturbance or litters or does something improper, that they can be asked to leave the area. So there's some kind of public safety.
It sounds like the parties are going to agree to something as mandated by the village that actually has more meat and bones on it than the original easement,
Clearly.
which actually left it open because it was ambiguous to almost any interpretation.
Does the school board know about this?
We have not gotten to the point where we're addressing satisfaction conditions. We're now we wanted to get to the end of these approvals, and we're going to be addressing both with the arbors and with the school district, the easements that have to be satisfied under your resolution. So the accurate answer is, I haven't spoken with anyone from the school district. So if you want to be involved, I'm going to be reaching out to counsel for the school district and trying to nail this down as an easement that we want corrected on the property.
I just think it's frankly, this is my position. I think it's foolhardy to approve things when we don't know what it affects and whether the other party.
I don't think there's an answer
That's
to that.
just my own position.
If there was an answer to that question, I think after all these years of actually reviewing these plans and with the school district knowledgeable that this petition, that this proceeding has been going on, there may not be an answer to Scott's question. But what I think is encouraging is that the parties are not ignoring the situation.
Absolutely.
They are taking affirmative action to lend definition to what otherwise is an uncertain and ambiguous
Correct.
feature, and it sounds to me that they will work out an arrangement that makes sense, in cooperation with the village.
That's correct.
I mean, my concern is due process. I mean, that was my original, I think, the issue that Scott raised, which I thought was a legitimate. If the school district had no idea what was going on and there was all this construction going on, but if they're gonna be involved in the process, if they're gonna be involved in defining what the feature is, then I'm satisfied that things will, the interests of the parties will probably take care of it.
They will. I'm going to make hopefully one final statement. Mr. Mendelson, if you have any specific thoughts or recommendations concerning how best to memorialize this as the initial draftsman of what's going to go across to the school district, I'll give you my email. Give me your thoughts. If you've got some brilliant ideas, I'm trying to keep it simple, but if you read what I read,
I did.
it's not a particularly good document.
I don't know enough to know what I don't know.
Scott,
So that's.
Well, I've
are you, pardon me, are you concerned that by us approving this, we could be harming the school district?
Yes.
In what way?
I don't know.
There you go.
Because John,
you go.
John, and that's why,
That's-
and it's
yeah.
not a fair answer, and I appreciate the applicant's response to this, and I don't know what I don't know.
Because I remember what you just read, that we discussed the safety during the construction, and hopefully that has been put in writing in the construction management plan. As to easement that goes to nowhere, I don't know. I don't know.
I don't know if it
But
would,
we,
I don't know
but
if it was supposed.
unfortunately, we cannot stay on, I don't know, we gotta move on. And I'm looking to you guys, are we doing something that we should not be doing by, I don't believe, I think we should go ahead.
No, look, again, my point is that you do have an easement that is reflected on the plans. And beyond that, it's not for this board to determine or, litigate or decide what the easement does or doesn't do. It's reflected on the plans.
It's
You've
still
made-
on the plan,
Yeah, you've made provision
Yeah.
for,
for safety.
for safety, and,
Yeah.
both in terms of advance notice and coordination with the district and specific safety protocols that are supposed to be put in place. I don't think there's anything else to do.
our action does not void that easement.
No.
No, not at all.
No, not
I
at
don't know,
all.
what else can we do?
Not at all.
Yeah,
The easement is there. It's
Yeah.
there right now until we change it.
yeah.
And it says what it says.
Anyway, unless there are other comments, we should have a vote on the.
I'd be remiss if I don't ask Mr. Steinman a question.
Oh, go ahead.
So when?
Would never be remiss.
When is it gonna be
My question
constructed?
is when?
When?
This construction,
When's-
you keep asking me that. The longer this process
For
takes, the
5
longer
years,
it takes
for
to get
5
the-
years, for 5 years I've been doing that. School is gonna go it would be closed in about a couple of weeks. It would be nice if we could do the demolition during the month of July, August, and before school reopens.
So.
Are you ready to do it?
We're getting much closer. In fairness, you should ask your building inspector that there's been a lot of contact between our client and their design team and the building department.
Let me ask you one
In
more
addition,
question.
hang on.
Yeah.
Because David's here, he deserves credit. We'll give him credit for one thing. They adopted a new regulation allowing the demolition of windows and glassware in commercial buildings, and it doesn't have to be done by hand. That will speed up demolition
Good.
considerably, and the Board of Trustees took that up at their last meeting or 2 meetings back.
Now,
So-
do you have, after tonight, do you have all the approvals you need?
So, I hate to
It's
have
yes or no? Is that,
So here's the answer. We think that the village, and Judd, maybe you can respond to this. I think Jennifer wanted us to go back to the Architectural Review Board one final time, and they're nodding. And you all should know, I did everything in my power to not have to go through this process this time. Judd, certainly Jennifer knows. I begged Jennifer, I begged Chris, I begged the mayor, don't make us go through for a couple of minor changes, 4 months of process. But you're very thorough, you're very cautious, and we have done that. So we're going to go back to the Architectural Review Board after having spent an hour and a half there presenting everything, and the chair was ready to vote that night. And to their credit, cautious counsel said, we're not going to do that. So here we are. I've gone through a finding statement for the second time to have it amended. Other communities, I would not have had to do that. But I played by your rules. So as soon as you give us all our approvals, we can really get down to finishing up the building permit application, please.
so nothing changes. We are always the one, we are always the one holding you up.
I would be remiss if I didn't give you an accurate answer.
That's not the one I was looking
An,
for.
an opinion in any.
But I will say that on my side, from the building department aspect, there are emails, there is correspondences, there's a meeting being set up, I believe, for next week, amongst their professionals and us. So things are rolling.
Yeah, I know that.
Things are rolling,
But
so.
it wouldn't have been ideal time to do the demolition. We know we have to do the demolition, to have done it this summer when the school is not in progress, rather than start doing it in October when the students and buses and everybody else is rolling on.
Well, with regard to the ARB approval, it is a condition, but it's a condition prior to the issuance of a building permit, not prior to a demolition permit.
It's just a vicious cycle. And I really, to me,
Fair comment,
not-
Judd.
yeah.
I wish I could get my client to close before the building permit was.
All right,
You had
all
to
right,
try.
all right, I
We're ready
think,
to go.
okay.
We're getting, all I tell you is
I-
we're getting
yeah.
much closer.
I think we need to resolve this.
I wanted to see you start before I leave the board.
Stick around.
Stick around. Okay, can I have a motion and a second to adopt the resolution of approval of this, of the amended site plan?
Moved.
Second.
Mr. Branch?
Yes.
Yes. Mr. Grzan?
Yes.
Yes. Mr. Mendelson?
Yes.
Yes. Mr. Weissman?
Yes.
Yes. Chairman Goodman?
Yes,
Yes. Thank you.
good luck.
Very welcome. Do you have any suggestions on each? There you go.
Okay.
He's not gonna come back to ask the extension,
Are
right?
you kidding? He'll do anything but. All right, our next matter and last matter is 19 Dorchester Drive with a lot merger. Okay, now, as I understand why we are here, this is really sort of a sketch plan conference. You have filed an application for a lot merger, but there's a steep slopes. I think there's identified by the building inspector or the superintendent of public works that you also need a steep slopes permit. So that's going to be filed too, along with the site plan relating to that.
That's an existing condition.
Right, right. But it's good that you're here on a sketch plan conference. So you'll get our views before you have to spend a lot of time putting, plans and everything together. So why don't you walk through the project and then we'll speak to you.
Well, first off, for the record, my name is Chris Scalfo with Optimum Building.
Oh, me?
We ready?
Sorry. Go ahead, sorry.
Sure, no problem. I'm Chris Scalfo with Optimum Building, and I'm serving as the general contractor for the proposed improvements at the property known as 19 and 23 Dorchester Drive, owned by Jason and Angela Rain. Although we've been working through revisions, we wanted to appear here before the board this evening, primarily as an introduction to the project concept, which includes the proposed tennis court, pool house, and related site improvements. Since the original submission, we have continued working closely with the engineer and Mike Nowak. And as part of the process, several revisions and refinements are currently on the way involving the grading plan, landscaping, tree plan, drainage design, and the recreational court layout. In response to the comments, we have already begun reducing portions of the impervious coverage associated with the tennis court and the pool house to be compliant with the village code, and continue to evaluate additional refinements intended to improve the overall site plan and better address the project's relationship to the property. Because of these revisions are actively ongoing, we felt it would be productive, of course, tonight to get feedback from the board and, if allowed, any residents to air any concerns that may have with this project so that we may reflect those concerns in our plan. We are hopeful with the feedback and comments made this evening, we can further complete and coordinate our submission package for the board's formal review and consideration, hopefully in next month's meeting. We appreciate your time tonight.
Steve Anderson from Gabriel Leasing or PC, the engineers and land surveyors. I'll explain quickly the project. It's 2 lots. One is 20,000 square feet per zone, and the other is 22,003. So it's just under 1 acre if you merge the lots. And we looked at it, and we, going to have like a sports court and take down trees. We've been working with Mike for a couple weeks now, and we're working out the impervious surface. We are now on our latest look at it below what you get when you do the impervious surface.
Yeah, how much impervious surface are we talking about now, above what's required?
It's just below. Yeah, well, no, it's the limit, the base area limit, and the in fact I have the document here. So, but we've been working out numbers, and we're still working out numbers to keep it below what's allowable. So let me just pull.
Now, you're doing calculation now as a single lot.
Yes.
Once you merge the lots,
Combine everything.
everything goes to one lot now.
Right, so we're assuming, if
So-
we add it together, it's the 40,000 and larger, is that it?
I guess
Yeah.
it's 42,000,
Yes,
something like that.
42. It's just under an acre. Right? So the allowed is 11,700, but we've been playing around with the sports court, getting sizes, and we're actually going to get the number down below that. So right now, the plan you have seen is over, but we're working, like I said, the court and the pool house to be below the allowable. So, and that's where we're looking at right now.
It's a novel concept, a tennis court in a residential R15. It's very unique. It's very unique.
It's R20, right? So,
I thought it was R15.
no,
It's R20.
R20? And I guess the reason you are doing the merging the lots, because you couldn't even think about the court unless you merge.
yeah,
Okay,
yeah. And I would like you to know that we still have to design for stormwater. We have to keep all stormwater on the site and 25-year storms. So we've done extensive perk test and all. We just have to figure out where. Once we get the final number, we just have to do the calculations and figure out where all the systems will go. So.
Judson, I went through our zoning code, and the only place I find the tennis court listed exclusively in a court, in the zoning code, was in the OB1. Every other place I did not see court listed. However, could be accessory use. Yeah, so it would be considered as an accessory use.
Accessory, and ultimately that will be for the building department to decide, whether it's permitted or not permitted in that zone, not for the board. But it could be an accessory use to a residential structure.
But going,
Well, that was right. The reason why we're merging the lot, because you can't put a tennis court on an individual lot unless there's a dwelling there and somebody's living there.
it has to have a principal
Right.
use,
So
which is a
now
dwelling, yeah,
merging it,
okay, sure.
It's under the code, it's allowed, provided, we follow the guidelines of the compliance with the size, setbacks and all that. So right now, we're trying to achieve the tennis court. We're shrinking the size of it so that we're within the boundaries of.
Chris, when I look at this project, I put myself in the shoe of your next door neighbor.
Sure.
That's how I approach it. And of course, by the code, you have every right to apply. Now, there are a lot, and hopefully we can work on this, but there are a lot of conditions that I hope my fellow board members would be looking at to make sure that, you enjoy your court, but not at the detriment of the next door neighbor. Yeah.
Yeah, I mean, how, do you have, I'm not as familiar with the area as I should be at this stage, but how close are your neighbors?
Well, right now the court is 15-foot setback off the property line,
Right.
both rear and one side. As you can see, the far left is the court. Now, of course, that's full size, 120 by 60. It's now shrinking probably 20%. To make it still a playable court, but reduce the size to maintain, to be under the allowable impervious.
I'm sorry, I have a question. Back to the impervious surface, and maybe it's the size of the drawing I'm looking at. I'm really trying to understand because you're close on impervious surface, right? Also, I don't really see ways to traverse the property. What's the plan for the residents to traverse throughout the property? Are you going to put in walkways or
No, so
they're going to go across the grass? I'm just curious.
The house at number 19, which is on the right side, so there'll now be further, more property, because right now where the property line is, we're extending the play area in the rear yard to continue through towards the court. So it's roughly, I think, 140 feet from the right property line to the tennis court. So that's all fairly level play area. And then, of course, the front yard is now going to be open, because I believe it's 85 feet from the curb line to the tennis court from the front street.
So I really don't see a logical path from the front of the dwelling to the tennis court area. I'm just trying to figure out, how you're going to traverse in and out the lot.
Yeah, get it a little closer. The current residents are going to be using the existing driveway and the walkways to the house. So the existing house at 23 is no longer there.
Mm-hmm.
So they basically will traverse through the property from the backyard of number 19.
Okay. So
So the whole
Okay.
property of property 23 becomes all usable property for his use.
so she's going to walk in the grass, is what you're saying? Okay.
Right.
I'm just asking.
Now in terms
Yeah, it's going
of,
to be manicured. We have, right now the tree plant is being revised, arborvitae bordering along the rear, the left side for privacy,
right.
and
Now-
all the way down, actually from the rear property line all the way to the front, and then crossing at the property line in the front, and then wrapping back to the existing fence at number 19.
How much space do you have from the court to the property line right
15
now?
feet.
How much?
15.
15.
Yeah, the code allows 6,
Because
but we've pushed
to
it.
to buffer the noise, I don't think just talking about single row or arborvitaes is going to be sufficient. I think you're going to have an extensive buffer, in my mind, 10, 15, 20 feet of vegetation buffering.
Yeah, well, yes, the arborvitae is obviously going to grow and fill in. I guess we'll have a conversation with Mr. Rain about any other fencing that could buffer sound
Right.
to the neighbor that's
Is
closest.
your client proposing to use this as just a daytime, or do you propose, or do you think about lights?
He's in attendance, so he could answer that question if you'd like.
Come up there?
Sure.
I'm pretty loud.
Yeah, come on.
Thank you.
Now, is your tennis playing loud? That's the
There's a lot of tennis players. So thank you for having me. It's Jason Ryan.
Hi, Jason.
Nice to see you all. The goal, as we were talking about, is to combine the lots, have a smooth grading between both. We have 3 boys who do sports and are very active, and so there'll be a smooth connection, which everybody's been working on, because there's a little bit of a slope, and then smooth everything out. You put the tennis court in place, and really it's a tennis and sports court. We've thought about the community, so there was an offer of us to put up lights. We're not doing that, so it's going to be during the day, because we understand and respect our neighbors, and, you know, we
So
have.
there
we
will
have
be no lights?
No lights, correct.
That's a
Okay.
step in the right
Correct,
direction.
correct. So no lights, and then the buffer will be it's basically a reverse J is where all the shrubs and the arborvitaes and then trees will be implemented to manage some of the clearing that we're doing on the existing trees. And it'll be ones that are a good base height, and then the goal is that they grow, to continue to provide incremental support. Across the back of the lot, our neighbors, so we're gonna swing the fence, so there's gonna be a full fence across the back of the lot. So it'll go across the back where the court is. Our neighbors on both other sides already have arborvitaes and foliage up that is all higher than me, so you, in essence, have a double buffer from the other lots that are adjacent to us.
And do you intend to use this just for your family? What's the intensity of use? This is gonna be tournaments or?
No, no, we're not, I'm not a professional tennis player. I grew up playing tennis. My wife plays casually, but similar to, you know, how we host friends and family for our pool, think about it as really recreational. We don't, our oldest is in 3rd grade. He's not professional yet. Maybe eventually we'll be there, but I don't think that there's any intention of, you know, widespread.
I kind of, you know, it's a conference, right?
Oh, yeah, that's a sketch
I'm
plan
kind of
conference.
raising these issues because this may eventually evolve into the conditions of the approval. So something to think about it. Because if there are too many
What do you think?
restrictions,
No Monica Seles grunting, John?
so if there are too many restrictions, you may, you know, it may not be effective for you to go this direction. So just something to think about.
Yeah, understood.
Yeah.
Appreciate that.
Yeah.
We've tried to be thoughtful in a way that we can enjoy it for our family and from a recreational perspective, while also putting up some of the right buffers, et cetera, and not doing lights and other things that don't disturb.
We are always, you know, character of neighborhood we are concerned with. And,
Sure.
so I think we do want to preserve that. Whenever we do something, I think that's something in the back of our minds. That
Well, I guess to that point, and this is a sketch plan conference, so there's a lot of interplay. What we want to do is we want to ultimately approve the application. We're not interested in denying applications, so we want to get as much information up front. And I'm wondering, out there in the audience, are there any neighbors that are here for this application? Okay, it may be good to hear them out,
Happy to.
just because it'll give you a heads up. What we want to do is we want the process to go smoothly, and we don't want there to be ambushed by issues at a public hearing. So would anyone like to come up and speak to what their concerns are about the project? Just a couple of minutes. You don't have to. There is a public hearing on this, but I figure I want to give the applicant an opportunity to hear you out because it may affect how they look at things, and let's get it out now.
I've spoken to Jason. He's come to the house and shown me the renderings and what he's intending to do. There are a couple of concerns, obviously.
Where do you live in relation?
I live at 24 Dorchester Drive, which is directly across the street from the new property that's being added to the existing 19. So I'm literally right across the street. You know, there are concerns about the purposes. Number one, I wanted to know, is there a plan to build a basketball on the same court that it was originally described to me as a basketball court with multi-use. Subsequently, listening to this, I have discovered that it's really a tennis court, not a basketball court. And I wanted to know, are there going to be baskets on the property, and are there going to be games, and how many? I'm concerned the noise level and the amount of people that will be using it. I understand it's personal use, but nevertheless, they're young kids right now, and before long they'll be grown kids, and they'll be in high school and junior high school, and they'll be having their friends over, and there'll be a certain level of concern in terms of the noise. The other thing is, I was concerned also about the likelihood of what this is going to do to property values, because it's going to affect my tax base. because obviously when you're combining the properties and you're making an investment, if you will, the original house was in disrepair, to put it mildly. I know the tax base on that house couldn't have been more than $800,000. Now we're going to be looking at a very different thing, and because of the improvements and the combining of the property. My concern obviously is what that implication is going to do to the tax base in the area, and because my taxes are pretty high, or at least in my mind, pretty high right now, and here we are, the original house that they purchased, I know what the selling price was, and now I know what the selling price is on the property itself, just the land.
So you're concerned that your assessment is gonna go up?
I'm sorry?
You're concerned that your assessment on your property is gonna go up?
Not only mine, but everybody in the neighborhood, yes.
Right.
That's a very big concern for me, because when all of a sudden you're talking about a property is being merged, my assumption is that merge will now be one giant piece of property, the original value of the purchase price of the Rains, and then the additional purchase of the property that was just made, plus the improvements and the tearing down of the property. And I don't know the full implication. I'm certainly not. I'm just talking about my concerns in terms of what lies ahead. I was also concerned about the fact that is this going to be a free situation now once it's approved, assuming that it gets approved? What's the ramifications down the road if they want to add another court or they want to add something else? In other words, is this a one and done, or is every time that there's anything being done on the property that is that going to require a further approval, or is this an approval creating a freedom to do anything you want going forward? That's another one of my questions. I also was concerned, and Jason mentioned that it is not a problem. I was concerned because it's a very old property, 1956, I believe. Were there any ramifications on tearing the property down in terms of what would possibly be found when you're ripping up a house and taking it down? And I don't know if it's going to be bulldozed. I don't know. But you're talking about whether there's asbestos with it, and Jason had said to me there is not. And I wanted to know about the air quality issues, if there's going to be anything in terms of tearing down the property and what that might do to the neighborhood in terms of dust and whatever issues are taking place when the property is being torn down. And I think that's the majority of what I had, at least for a first blush.
Yeah. No, thank you for that. And all of those questions are going to be answered.
Okay.
Okay, so there are a lot of issues about process, and the tax issue, I can't tell you off the top of my head. I don't know what it is.
I didn't expect you to be able to, but I wanted to voice my concern
Yeah,
about it.
of course, yeah. Okay, that's great. I appreciate that. Thank you. Any other neighbor?
I just have a couple questions, but can I speak from here?
No. It's okay, though.
He's a wonderful neighbor.
Well, that's good.
Hi, Pam Caplow, 20 Dorchester Drive, and I live catty corner, and I'll speak into the mic. So a couple questions I have. A regular-sized tennis court is somewhere about 7,200 square feet. This is looking like 11,000. What is going to be encompassed inside that tennis court besides a tennis court? That's the question I had, because this tennis court looks like double the size of what the footprint of the house looks like. And a tennis court is 7,200, maybe I'm off by 800 square feet, but it's not 11,000 or whatever it is. So the question is, what else is going to be encompassed within this fencing? The other question is the buffer zone. Just a few people in the neighborhood couldn't be here tonight, so they had asked me a few questions, and this was one of the questions from one of the neighbors. They're really concerned about the buffer zone between the back of the tennis court and the side of the tennis court. One layer of arborvitae doesn't necessarily do it. I back up to the school, so I know what one layer of, I put in 14-foot arborvitaes like 15 years ago, and I know that the noise still carries from the school right through my backyard, so that does happen. So that's the question I have about the buffer zone for the perimeter. The other question I had was, or maybe the idea was, maybe the pool house could be longer and narrower type thing, and they could actually reconfigure it somehow that way. I was just looking at the design very quickly. I think it looks like a very cool concept, but I guess the concern is the lights was a concern. That was answered. And the question is going to be the noise level and how far that's going to carry. I don't really know, when you're playing ball, I know my neighbors play basketball, and this is very funny, but when my kids were younger, we were going to take down the whole entire left-hand side of our tree in our house and put a semi-basketball court out front. And then I woke up in the middle of the night and said, oh my God, we can't do this. These kids are going to be out of here in 8 years, and they're not going to want it. So I do hear my neighbors playing basketball next door in my house on the whole left-hand side. And I actually now think about when my kids were playing basketball 24/7 for 8 years, that those neighbors never complained, and they were amazing. They're not living there any longer. But I think the concept looks really cool. Just it looks very big to me in terms of the size. That was the question that I had. And as long as the shrubbery and everything else, and if the fence is going to be, I don't know, it's 8 or 10 foot, if you're going to put in shrubs that are going to be 6 foot tall, we're going to be waiting for about 5 years to have coverage there. Maybe at that point you have to go in with a little bigger shrubs and a more layered kind of a look to give a little bit more depth in terms of the sound and what's going to happen. And the other thing I wanted to share was, I don't know how many years ago, but Fred knows this. We actually spent a lot of time talking about digging up and what you're going to find. We spent an enormous amount of time, maybe Mr. Grzan remembers this, fighting with everybody at the Ridge Street School when they wanted to actually redo all those fields, and they were going to bring in all the fill from everywhere. And it was a big thing we had going on here in the community, not to do it, thank God, because it was all found to have carcinogens in it. I don't know if you remember back then, about 20 years ago that happened, or 15 years ago. So his concern is, if they're doing fill or anything like that, that it should be, I'm sure it would be perfect anyway. But it's just, we did have that problem at Ridge Street School, and they never did it. They stopped it.
I think that's the easiest concern to work around.
Right.
Because everything is going to be tested.
Right,
So
exactly.
no soil comes on site unless it's tested.
Just the landscaping in the front of the street also, so I'm sure you're gonna have it very private, so no one's gonna see in the back. And as long as we get invited, that's really the key. Seriously, let's get down to the, now, is this gonna be like basketball and pickleball and everything on one court? Is that really the intent?
Yep.
Okay,
Yeah, go ahead.
thanks.
So Fred, to your question, and also to the point of trying to make sure we're being thoughtful, we're not doing a full basketball court, because that would create the scenario where you've got 5-on-5, 10-on-10 running back and forth like a big gym. The goal is to have, on one half, is to have a hoop. Kids like playing basketball. And so it would be a full tennis court, and then the one half has the basketball hoop and the lines associated with it. But we don't intend to take the net down, and so that people can run back and forth and screaming and that going crazy. They're kids, obviously. To Pam, on your question on the court, you're correct. I mean, we've talked with Mike about this. It's a regulation court for the pros, with legacy Roger Federer serving, and they stand, 30 feet back to catch a 130-foot serve. The dead area is going to be shrunk to help us manage that impervious question, and we're finalizing some of that right now. And then around the court is either going to be grass or some impervious turf-esque surface that we get approval for that helps fill out and create some room in between the smaller court and the fences, so people aren't in a cage. But that surface of the court is going to look a little bit smaller than a normal professional court as a result of just some of the nature of what we can put down. And so we're working through that. And then the last on the soil, the goal is to fully take out the house. The house needs to be taken down. Fred said it. I mean, we know what that house is. Nothing's been done with it since 1956. And which includes taking out the foundation, and we've gone through all the approvals with the engineers and then the process and around that. But we actually, as we merge the lots, our lot is a little bit higher than 23, and so the goal is to smooth with, for the most part, as much existing soil, et cetera, we have to create a smooth surface. The reality is the court and the nature of the lot has to be towards the back because that's the flattest part of the lot. We know that the lot's, it's straight up and then flat, and so I think the code, notwithstanding what the committee and everybody guides us to, the code allows us actually to get closer to the property lines, and we're trying to be thoughtful and have it further away from the property line so we can create some of those incremental appropriate buffers. And the goal is to, by not putting a fence, we want our privacy too, just like you all do, by not putting a fence in the front because that won't help anybody. It's to put larger, starting at 6-foot-esque, fast-growing shrubs, bushes that provide that buffer, north-south, and a growth east-west, which we're working through.
Anybody else? Last.
So just for,
Mr. Gentleman?
just for confirmation, it's gonna be a tennis court on one side and half basketball court on the other side. That's why it's that big.
A full tennis court, yeah.
Okay.
So, correct.
Yep,
that is
okay, so full tennis court on one side and half basketball court on one side.
Correct.
Okay.
Just on the half.
Okay.
Correct. It's just, there will be one hoop. Okay. Correct.
I think that's the first time I'm hearing basketball. At the beginning was always tennis court.
That's
But
why I make it clear what's
Yeah.
going in.
Yes, sir. Identify yourself and
Thank you. Jim Feldesman, 37 Rocking Horse Trail. 3 houses away, I guess it is. So I'm not as concerned. I'm talking about more about another lion in the cage, if you will. Water. I will tell you, Mike stepped away. Since the pandemic, we have had nothing but more water coming down the hill because we're on the bottom.
Right.
And I didn't know enough in the beginning, my wife and I. So we have our next door neighbor. Actually, I think Jason had put in a pool first, and then our neighbor directly behind us put in a pool. And I know that there are, I don't know whatever you call them, to catch the water.
Coltech arenas. Yeah.
I don't know how much they work. I'm not saying they don't, but I can tell you that the back part of my property, because it does slope away from the house, but it goes right towards my neighbor as well. We end up with, when it rains or after it's rained, we got puddles.
usually, Jim, happened to me, but it took me a long time to realize what happened. When pool goes into the ground, there are catch basins for the roof water. Now, if you're going to put the pool down, most likely those catch basins that contain the roof water are run away, and they disappear. And now all of a sudden, that roof water becomes a surface water, has no place to go, comes from the roof, and water usually goes down the hill. And that's what happened. Michael knows my scenario for last 30 years. That's what happened to me too. Yeah. In my own house. I'm the last house down the hill, and the people up on top of me, they put their pools in, took away the catch basins from the roof water, and basically water is coming down on my property. I don't have grass in my backyard for last God knows how many years.
That's not the answer that I was hoping to hear. And I haven't spoken to Mike, maybe about a year and a half now, I guess. He hasn't missed me, trust me.
But I think, Mr. Scalfo, the drainage on this project, it's a major concern and something that is going to have to be addressed.
I will
Yeah.
tell you.
Especially with retaining walls, backfill, and too much impervious surface. Even though the code may allow you, but you still have a tremendous amount of impervious surface.
Believe me, I mean, we've seen each other, we've
below. Kids are adorable. But I gotta tell you, I mean, we, from that water, we ended up, and Mike and I had this whole conversation maybe an hour and a half, 2 hours ago. And I repeated it because we had put in some sort of a I don't know what you call it, drainage system coming down to handle some of the water to go out and doing it. And then, I don't know, 2 years ago, we got a visit from Mike's people. I'm saying your people, I don't know who it was. Actually, it was a gentleman from the fire area, I think it was, who said, I needed, yeah, I think that's where it was. Because we had water that was spilling out to the street. Well, guess what? They said you can't do that. So what did I did? We got a permit, and we ran a pipe through underground, ran and into the storm drain. It was money that was probably well spent, but didn't want to. And I've been told that you're not supposed to have water that goes dripping down the street as well. Okay. Not picking on you, but we know that there was a drain at the foot of your driveway, which is closed. And I will tell you, as of earlier in the week or last week, we noticed again, water coming down from your driveway. If that's what we're seeing there now, I can't imagine what will happen with, depending upon what gets approved for the watering, with the whole system that you would put in.
Well, I can say that Rybrook is very severe when it comes to the stormwater management. Everything has to be captured. It's 100% capture. So this is going to be one of our concerns, certainly one of Mike's concerns. It's always a concern with the project.
I know it's his concern.
But where is this project has, a lot of impervious surface coverage, is going to become, even more of a focus. So there's going to be a lot of discussions about this and how to go about doing it. It's actually sort of a battle of experts sort of thing, because it's the engineering that can make it work or not make it work. And so but it is a topic that is going to be sort of front and center with most of our projects now, because Rybrook, we have water all over the place. So it's not unique to this particular part of the village for sure, but we're going to be. You're not raising a concern that's already not a concern of ours.
I think during the course of deliberation, the question is going to be asked: did you think of other alternatives? And I think you raised a beautiful question. The upcoming sport is pickleball. Takes half a. You could have a basketball court and a pickleball court half the size of the tennis court. No, you don't know. Just a comment.
I appreciate the comments. No, so thank you. First, the water is obviously our concern, and Chris has guided me on that. And I know everybody's focused on it because of the nature of Rybrook, the brook in Rybrook, including working through dry wells and those type of things. And to be honest, her driveway is going to be removed, and that's where a lot of the water comes down. So hopefully that removes one scenario of where water flows, and got grass and other things there in the dry well. But you'll be able to see a lot of that, and we know that the committee will is serious about that. We've thought about other things. We really I grew up playing tennis. My wife plays tennis. The boys play tennis. They don't play pickleball.
Just a suggestion.
Yeah, I appreciate it. And we've thought about these different things. We've thought about different options for that space, which we love our backyard. We're very fortunate. We've got active kids. We've got friends who are active, and this was something where when we were going through and even evaluating whether to purchase the property, this was in our minds. And so, thank you for the suggestion. But as we evolve the plans, that tennis court and half basketball is one of the things that is we're most interested in.
you know, when you get to my age, you forget
We
tennis.
do
You ra-
pickleball.
you ra-
At
you
our
ra-
age, we
you
do
rather run
pickleball.
pickleball. Less running to do.
Listen, I need those three boys running around in circles as much as possible so that they
I
don't
get it.
destroy themselves and everything else, and that's a little bit of it too, but,
Okay.
I would just say, just understand the extent of the stormwater management that you're gonna have to deal with. And let that guide you with your decision making.
understood.
Yeah, look, I think, hopefully this has been helpful
Yeah.
for everyone concerned. I guess you'll work with your professionals. My advice is this, just in terms of experience with an application that just came before you not that long ago. We have a great staff. We have wonderful professionals. We have people that really have their hearts in the right place in terms of trying to make the community really work, and they take these applications really seriously. So if there are issues about how to manage impervious surface, maybe alternative ways of doing things, issues with engineering, speak to our people, speak to Mike, speak to, be in touch with, Sarah. These people really know what they're doing. We had an application that came before us not that long ago. It was an incredibly complicated stormwater management issue. We never even thought the project could happen. But there was a lot of interaction between our respective professionals. There were a lot of very complicated issues that are still being worked at, but I think both parties operated in really good faith and very efficiently. And so, avail yourself of the resources that the village has to help you guys manage the code, impervious surface, engineering issues, things like that. And the better the dialogue is, the better the result is gonna be, so.
Yeah, they're getting you to a yes.
We'll get you to a yes.
Mike's been great so far in guiding us and saying what's the art of the possible is, and
Yeah.
Chris and the team as well. So
I think there are about 5-6 areas that at least I was thinking about when I was looking at the agenda this afternoon. And one, right off the bat, you addressed no lighting. To me, that was the number one concern, just because of the neighbors. Intensity of the use or the hours of operation, you kind of addressed that one too. Landscaping and a buffer, I think we all agreed that one row of the arborvitae is not going to do it. Drainage, big issue. What's the other one that I had there? Setbacks. It's by the code, but the code is there. And then we got to work around. Sometimes you have to work around the code to approve something that you think is feasible. And of course, I think I mentioned the fencing and the sound screening. Those are the concerns, and I think they could be addressed.
Yeah.
Yeah.
Got it. Okay, so I guess next month, we're gonna have, a site plan, a steep slopes application to fill
I
out.
think the lady in the back wants to talk. Oh, you should be up here talking. Just making sure.
Yeah, I'm just confirming with Mike, that's sort of next on the agenda, for a site plan to be submitted. What's to be submitted?
So the next order of business here would be for the applicant to get all their plans in order, file a actual site plan drawing, site plan application, all the paperwork, and then it would be reviewed by building department and come to you as a formal application for lot merger and site plan all in one shot.
Right.
Correct.
The first step is, of course, approval of the site merger.
Correct. That would be
Cannot
the
have
first
discussions on
step.
the tennis court unless the site merger.
Correct.
Right. that'd be part
Correct,
of the
but
same
you'll review everything in tandem.
Okay,
Correct,
of
yeah,
course,
yeah,
but
right.
there is still logical
there's a- yeah,
sequence.
right.
Yes.
Yeah.
So,
And
like the original, the package that I submitted had, site plan review application, subdivision application, short environmental. So
Correct, and that was for the lot merger. So the site plan application needs to be revised to include the pool house, the sports courts, that stuff. that needs to be modified for that, then you need a site plan drawing that the board's gonna approve, which is almost there, which you guys are working on. So, and then all your imperviouses all have to be nailed down. So, because the building inspector did not do a zoning analysis on any of this, so that's why we need all of.
The other day, yeah, so he's privy to what's going on as far as the placement of the court and doing a walkthrough on the existing house, which brings up the question, does the planning board have the approval over the demolition of the house, or is it strictly building
I
department?
think it's the building department,
Okay.
right? But they'll probably, what's the requirement? They'll need a demolition plan?
Well, yeah, I mean,
It's the things like that,
I saw
yeah.
Steve the other day at the house, he did a walkthrough, we're just waiting for Con Ed, termination letters. Those are the last two pieces of the puzzle.
Right, right. No, they will deal with that.
Application's been in, water's been shut off, electric's been disconnected, gas has been, meter's been removed, so, again, just waiting for Con Ed to get
Right,
it
to
done.
get the-
The letter, the simplest part of it, takes forever, but, that's kind of the last end of it. And there was also a question about the sewer line, because we have a sewer line at number 23.
Right.
With the pool house, proposed pool house in the rear, as far as being able to use that sewer line versus having to go now tie into the existing house that's remaining.
Right.
Much easier to just tie into a sewer line that's basically sitting there, waiting for, or just abandon it. But if it would be beneficial for us to not have to disturb more of the property of the existing home to acquire the sanitary.
Right.
So a couple of things on that, only because a few of the neighbors had asked. When the house is demoed, the building department does look into any asbestos abatement or lead, things of that nature all have to be abated before the house is able to be knocked down. Windows have to be removed, and then as part of the removal of the home, whoever the contractor is, they have to have water on site and the things like that to maintain the dust in knocking down the house. With regards to the sewer, that is a question I need legal counsel to advise me upon, because in essence, excuse me, each residential lot is apprised one sewer connection. In this case, you would have two sewer connections, but only pay one sewer tax. So that's improper as well. So, it sets a mandate that, I can't approve, because then you'll be getting a benefit of two taps, paying one tax, on that. So we'll pursue that offline, and we'll talk about that once I get an answer from council.
Okay, all right. I think we don't,
Yep.
we know what the concerns are.
Got
We're
it.
addressing everything that we need to. Of course, the stormwater is probably most important.
Speak to your neighbor, that's the most important.
Yeah.
Just on the stormwater, I'd like you to know that we're retrofitting the whole property, so even the existing pool and the house will go into this new system. So if there's any runoff now, we pretty much take from like the pool or the house, we're pretty much gonna take care of that now.
You may actually improve the
Yeah,
runoff
yeah.
because of the Coltex.
Right,
Yeah,
and
depending how many
you
chambers
guys-
you have, yeah.
you really do have a strict stormwater, because
Yes.
we're not allowed to do pre and post analysis. It's straightforward. Water goes into the system.
No, the 100%
Yeah.
capture requirement
Yeah,
is a
so-
very big,
Yeah.
very big deal.
Yeah.
Yeah. All right, well, thank you, gentlemen. Thank you. Thank you all for your input.
I felt this was like.
Motion and second to close the meeting?
Pam, their kids were going to school
Second.
together. I haven't seen those two in ages.
Who moved?
I did.
Larry, Lenny, second. Kevin, all in favor?
Aye.
Any opposed? Thank you.
Bye-bye, guys.